Welcome to CSIS Online. The way we bring you events is changing, but we'll still present live analysis and award-winning digital media from our Dracopolis Ideas Lab. All on your time, live or on demand. This is CSIS Online.
Good afternoon, everyone. Thank you for tuning in for the CSIS US Innovation and Competition Summit. As a part of the project on renewing American innovation, we thank you all for being here and for Dr. Yan Meniere and the rest of the CSIS team for putting this together. We just concluded a session this morning on the state of US IP policy and international competitiveness, led by Andrew Toole, the former Undersecretary of Commerce and Director of the US Patent Office, who is also the co-founder of the Renewing American Innovation Project here at CSIS, along with former Director of NIST, Walt Kopan. The panel that Andre led was with leading IP thinkers and judges, and it really highlighted the state of affairs vis-a-vis IP policy and the urgent need of a comprehensive plan to up our game in the United States vis-a-vis innovation and intellectual property. I found that exchange striking because here we are at the crossroads of appreciating and recognizing the urgent need to invest in R&D, in innovation, in science and technology, supported indeed by many bills that the Congress is considering and passing today. And yet the role of intellectual property in driving innovation and in driving economic growth is not well understood. So in this panel, we are trying to address this topic head on. We call this panel the economic benefits of IP protection. And we have today a perfect opportunity to learn from the chief economists of the US Patent and Trademark Office and the European Patent Office. So allow me to introduce our panelists today briefly, who I've had the privilege to know and have followed their work for a long time. Let me start with you, Andrew. Dr. Andrew Toole, he is the chief economist at the US Patent and Trademark Office and a research associate at the Center of European Economic Research Centers, the ZEW. And he's had experience that spans across the private sector, academia, and government. While completing his PhD in economics at Michigan State, Andrew was a senior economist consulting for the industry. And he's been a faculty member at Illinois State University and Rutgers University before moving on to the government. And as an academic, he advised in science and technology policy issues at the National Academy of Science, at the National Institute of Health, and the US Department of Agriculture, where he worked before joining the US Patent Office. And indeed, his research has focused for a long time on economics of innovation, intellectual property, and related science and technology policies. So a perfect panelist for this topic. Andrew, welcome. We're glad to have you here.
Thank you, Kirti. I'm super happy to be here. And I just want to say thank you to everybody for organizing this event on a very important topic.
And let me also introduce Dr. Yan Meniere. He is leading the Chief Economist Unit at the European Patent Office. Now, this unit, as they call it in Europe, was set up to provide economic insights into issues relating to patents, innovation, and economic growth. Yan is a professor of economics on leave from Mainz Paris Tech, where he was the leading the chair on IP and markets for technology until joining the European Patent Office. So his research and expertise too, for a long time, has been related to the economics of innovation, competition and intellectual property, technology standards, and IP issues in climate negotiations. He's written a number of policy studies for the European Commission, French government, and other organizations. Welcome, Yan.
Thank you, Kirti. Good afternoon, everyone. And it's a pleasure to be here, and I'm grateful to you and the organizers for this opportunity.
Thank you for both of you, two economists from the field of IP and innovation in their research, in their work in the government. Let me tee up the key essence of our discussion and launch into the Q&A right after that. Economists have long articulated the critical role of innovation in driving economic growth. We've known this from the time of somebody we all economists know, Robert Solow's neoclassical economic growth model. We study this in textbook. It clearly displays that the primary driver for long-run economic growth is not labor, not capital. They play a role, but it's really technological progress, because other things like labor and capital can only scale linearly, right? You put in 1 unit of input, you get 1 unit of output. Technological progress is like a shock. It has a multiplier effect by increasing the productivity of everything else, of labor, of capital. Most governments today, their plan reflects the focus on innovation leading to technological leadership. There's this recognition, not only for economic growth, but also for concerns related to national security and tech sovereignty. But what is less understood is the role of intellectual property in driving this kind of innovation. From these early works to today, the question on whether intellectual property enables or hinders innovation has been sometimes unanswered, sometimes ignored, sometimes answered ambiguously. Now, it's an important question because in today's knowledge economy, one led by tech innovation, the question is of critical importance and of actionable importance. A few decades ago, as an example, 80% of the market value of S&P 500 firms was explained by labor and capital assets. Today, it has reversed. 80% of market value is explained by intangible assets. Now, they come in various forms like skills and ideas and patents and copyrights and trademarks. But since intellectual property is a mechanism that has been widely accessible to anybody, big firms, small firms, individual inventors, universities, many economic historians have described this intellectual property as a key instrument for the democratization of invention, making economically feasible inventing activity available to all. At CSIS, we are embarking on projects to empirically examine and explore the mechanisms by which IP drives innovation and what kind of innovation takes place if intellectual property is available or not available in society. So with that, I would love to ask this question with our experts on this panel who have been longtime researchers and have been in patent offices of very important economies and jurisdictions. So let me start with you, Andrew. What is your view on the link between IP and innovation? And what do you see from your vantage point at the USPTO as its chief economist?
Okay, great. Well, thank you again, Kirti. I appreciate that question. It's a very important question. I think that the word innovation is used frequently in press and in policy and in academic work. And I think it's important to start with what do we mean by innovation, right? Innovation is when a new product, process, business method comes into the marketplace. That is to say, when people can actually use that product, they can have that service. And so innovation is when it is available and exchanged in the economy. And we know that innovation actually is a function of a lot of factors, right? So intellectual property is one of the factors, but there are other factors that feed into whether a company is successful, for instance, in introducing a new product to the market, right? And it's a complex process. But the role of intellectual property, in my view, is actually very, very important. It's not really obvious to the standard consumer who just buys the smartphone, for instance, what the role of intellectual property is to bring that smartphone onto that shelf, right? But intellectual property is just one way to think about it, and its role is simply to recognize that it is an intangible asset. One of the most celebrated aspects of the intellectual property system is that it protects the inventors, in the case of patents, It protects the inventors from others who might want to use that invention or make or offer for sale that invention without authorization. So it allows them to exclude others from using their invention. That exclusion actually provides that innovator, when they get to the marketplace, with an advantage, right? Assuming they can make it there. That's not an easy thing. I hope we can touch on the long and circuitous process from going from, let's say, a patent to actually getting getting a product on the market. The patent protection, once obtained, does help the innovator in the marketplace capture a fraction more of the revenue that they would than they would otherwise obtain if other competitors could come in and use their idea that they had invested so much time and energy to create in the first place. So that protection creates an economic benefit, and that economic benefit feeds back to become an incentive for the original investment of energy, creativity, financial capital, and other factors to actually come up with that. There's a second, so that's the most celebrated kind of aspect of the patent protection, is that you get this incentive, this reward that you can potentially yield if you're able to get to the marketplace. The second part of this asset that I really want to emphasize that's not well understood is that once you get a patent, for instance, and this is true of the other intellectual property assets, intangible assets, once you get this asset, you get to choose as the owner. You get to choose how to proceed with the development, the commercialization, who to partner with, who to perhaps license it to. And these rights, these control rights to the actual invention, provide a tremendous benefit that feed multiple other parts of the economy. So for instance, maybe the product isn't maybe the innovator, him or herself, is not going to take that invention, do the development, and introduce the product themselves into the market. Well, they can license that, and the rights that they have as the owner to license that is a very important part of its asset characteristics. And then they license it, let's say, to another company who can then develop it and market it. So it's not just the financial incentive that's provided by the protection from intellectual property, but it's also the rights to choose who to partner with and how to commercialize that make intellectual property so important for innovation. And I guess I should say one final thing, and I don't know what Yann's going to say. I hope he has a different take on this a little bit, but some of us, we talk a lot in different meetings and we tend to agree on things, but let me just mention one other aspect that maybe Yann will develop more, or at least we might be able to develop more in this call, and that is that the legal system and they call it the grand bargain, right? So for getting the patent protection, which allows the exclusivity and protection in the marketplace, for doing that, the actual patent owner has to disclose that invention to the public. So the disclosure part of it, which is different than the other two parts that I just talked about, that actually feeds further invention and more clarity into into technological development. So I won't say too much more about that at the moment. Maybe we'll talk more about that soon. Mm-hmm. But those are the three aspects I think that people should recognize when they think about intellectual property feeding innovation. And there are complex ways, but those three characteristics are very important and have multiple implications.
So really the three key themes that you described are, first, providing the fundamental incentive to innovate in the first place. Second, technology transfer. You can come up with the idea, but you don't have to carry the burden of commercializing the idea. And the third is essentially this method for disclosing your idea to the world and letting them innovate further in return to a temporary protection to your idea. Yes. Fantastic additions. And let's unpack those themes a little bit more. But Yann, same question applies to you. What is your view on the link between intellectual property and innovation? And what do you see from your vantage point at the EPO as its chief economist?
Right. So I think that Andy has covered the key points for IP as a whole. And But let me elaborate a bit more on IP and patents, on innovation and patents, and indeed on disclosure. So that's a complex enough topic, actually, patents and innovation. It's complicated because it's very important, and at the same time, it's at the crossroad of legal aspects, technology aspects, and economic aspects, which makes it very complex to grasp and to analyze empirically. And as a result, my view, at least, is that there has been a lot of economists talking about patents and innovation from a theoretical perspective. That's easier. It's more difficult to empirically document how it works. And so you mentioned works by because it's very granular, actually, if you really want to understand the mechanics. And so you have some economic history that's very valuable, but well, we are talking about innovation, so the world is changing. It's difficult so the historians have to catch up with how the world is evolving. So some lessons can be learned from there, but not everything. And then you have empirical studies, and it's difficult to find data. It's difficult to analyze causalities, and with Andy, we are struggling with that, actually, like all the economists in the field every day. But there are some valuable studies, nevertheless, and let me quote one. Actually, it's a paper published in 2013 in Econometrica, so the best possible journal, I think, in economics, in empirical economics, by Bloom, Chankerman, and Zandrinen, and they used patent data from the US, actually, to assess the social rate of return of R&D investment. And so I will not tell too much on the paper, but the main results, the main point is that the social rate of return of R&D is estimated to be 55%. And the private rate of return is estimated to be 21%. So when, as a private investor invests in R&D, if I get a return of 21%, but there is an additional return of 34% for the rest of the society. So put differently, $1 for me as the owner of profit generates more than $1 for the rest of benefits for the rest of the society. And that is really the crux of IP and patents and innovation. Investment in R&D, in innovation, creates a lot of value, private value and social value. And this is what the IP in general and patents in particular are meant to support. And why it is so? It's because when you invest in R&D, you ultimately invest in creating knowledge. And knowledge is information. And as such, it's different from the other types of goods. It's different from an apple. I buy an apple, I eat the apple, there's no apple anymore. If I create knowledge, then the knowledge is there to stay. We all know the Thales-Pythagore theorems. They have been there for centuries. We are not the first one to use them, not the last ones. It's there and people can build on that. And this is the value of knowledge. This is why it has a huge social value beyond the benefits that Thales or Pythagore could derive from it at the time. So we need to incentivize investment in the creation of knowledge and innovation. And if you just let the market do that, you will have some investment because they are private returns, but not enough because you need to investment up to the social returns. So you need some mechanisms to incentivize investment in knowledge. And if you don't have these mechanisms, people will invest, but then they will keep the knowledge secret and they will destroy the social value of the knowledge. And this is where patents come into play, indeed, because that's a way, as Andy said, by protecting the knowledge, it's a way to ensure that the inventor gets the returns on the invention. But it's also a way, as Andy said, to ensure the diffusion of that knowledge, because any patent application, be the patent granted or not, has to be disclosed, has to be published. There is a published description of the invention, and that means everyone is able to consult that information and build on it. And that includes building on it by contracting with the patent owner. There is also a misconception that when I have the patent, I keep the monopoly. Well, most of the time, it's not the case. There are collaborations. In fact, you need to work with other people. And it's very difficult to do if you keep the knowledge secret. There's the paradox there. Actually, if you want to convince someone of the value of your knowledge, you have to show it. But once you have shown the knowledge, I mean, there is no point for the other guy for buying the knowledge. It's disclosed. And the patent is a solution to that. It's a way to organize transactions around the knowledge. And that's very important. Actually, that's increasingly important in today's economy, because innovation does not take place in silo. It's based on collaboration. So that's a last point that I would like to add is the decentralized nature of the patent system, because I was mentioning the need for a policy mechanism to support investment in knowledge creation, in innovation. And we can think of other mechanisms. Actually, there are other mechanisms like public subsidies, and they are important, by the way. Public research, for instance. So it's important for upstream research when there is no obvious private benefits, but it's very difficult to organize. I say that coming from France. Actually, you need a government organizing everything from the top and trying to regulate the economy and decide what is the right project, what is the wrong one. That's very difficult to do. You need a lot of information and expertise to do that. And the real strength of the patent system and IP system in that respect is that it's decentralized. I have an idea, I think it's a good idea, then I try, I invest, and if I succeed to develop something, and I can get an IP right, and I can keep investing in it to bring it to the market, as Andy said. And this decentralized nature of the IP system and patent system, as opposed to government investment, is very important and often overlooked, I think, in the economic and policy debate.
Yeah, such fantastic points, and sort of like fundamental points, right? Like, first of all, this myth that patent is a monopoly. I mean, it is a mechanism for disclosing knowledge in return for a temporary protection. It is a mechanism for making it available to the world so that others can use that idea, not the opposite. Fundamental point. And knowledge is the only asset that grows by sharing. The other one that, there has to be a balance between returns and diffusion, because otherwise there won't be the incentive to have the idea and disclose it in the first place. And finally, the centralized versus decentralized. So I think, we'll get to the sort of the debate on the intellectual property system and other ways of innovating and all that. But I think it's a nice framework to look at mechanisms of innovation in this way. Patent system or intellectual property regimes are a decentralized, maybe democratization, decentralized way to create innovation, providing access to anybody. And a story comes to mind, during the times of late USSR, at the end of the era, Gorbachev's time, his aide goes to London to study about how the bread supply chain works, and he's shocked to see that there's never any lines or any shortage of bread in the bakeries or in the grocery store. So he asks, take me to the person in charge of bread supply in London. And of course, the secret was that there was no one in charge. We have learned through history that decentralized systems are just more efficient. Centralized systems don't work. So we can get rid of IP, but we're going to live in a world where innovation comes from only mechanisms where there are clear ways of protecting ideas through other means, like vertical integration or conglomerates or large big tech, forming these big firms where you're taking your ideas, you're also creating the products and monetizing your ideas in that way. We'll get to all of that later, but I really want the audience to hear a little bit more about some fascinating work your offices have done. So for everybody's knowledge, both the US Patent Office and the European Patent Office, US Patent and Trademark Office, I should say, do regular studies on looking at measuring the economic contribution of IP to the economy. There are several studies that both can talk about. So let me start with, again, this time let's start with Yann. Your office has most recently done a 2019 study on economic contribution of IP to the EPO. There are many others, that you have talked about and mentioned that touch upon that theme. Could you share with us some key highlights, what we can learn from mild-mannered economists who look at the numbers and try to understand the contribution of these mechanisms to the economy?
Sure. So one first point here is that, so I come from the European Patent Office, but when we talk about the value of IP in the economy, as you mentioned at the beginning, as Andy said, it's all about, at the end of the day, about intellectual, intangible assets, and IP is a way to protect, to organize that, and therefore it does not make sense to focus on patents only. Typically, these studies we carry them out in collaboration with the European Intellectual Property Office, in charge of European trademarks and designs, because we want to have the holistic view. So we focus on the holistic impact of IP. And we have a number of such studies. The first one, which is the twin study of the one prepared by USPTO, is a study on the contribution of IPR-intensive industries to the EU economy. So we define IPR-intensive industries as industries that make an above-average use of intellectual property rights in terms of number of rights per employee on average. And we show that actually these industries are really the engine of the European economy. They account for 45% of GDP in the EU, 39%, where 29% of employment directly, 39% if we include indirect jobs. The bulk of EU trade, like 80, 90%, depending on the metric you consider. And they create very well-paid jobs. The wage premium is of 50% on average as compared with other industries, and up to 72% for patent-intensive industries. So these are impressive figures, but it's important also to put that in perspective. What do they mean? In fact, one first element is that the contribution to GDP is 45%, to employment it's 29%. It means that there is a lot of value added per employee in these industries. They create more value added, and whatever the threshold you take to define what is an IPR intensive industry or not, the more you go towards the IPR intensity, the more you see that a lot of value added.
Not just jobs, knowledge intensive jobs.
Yes, highly paid jobs, because they are highly productive, because there's a lot of investment and creation of intangible, and that's the point. That's the key point. And likewise, they account for the bulk of trade. They generate a trade surplus for Europe, because they drive the competitiveness of the European economy. And that's why IPR intensive industries are important in Europe, or in the US. It's exactly the same pattern. You may change the metric a bit, but you still have this pattern of industries that invest in intangible assets and create more value than the other industries. So we do that at the industry level, and we have a similar study checking at the company level, and we find actually very similar results. And what is particularly interesting to me is that when we look at the size of the companies, we see that large companies that make use of IP, who make more use of IP, are more performant in terms of revenue per employee. But actually, this performance premium is much higher in the case of small businesses. So small businesses that use IP, meaning small businesses that invest in intangible, in innovation, make a huge difference. They are super performant. So the premium is about 55% higher in terms of revenue per employee as compared with other small businesses. That's 68. That's pretty high. And if we look also at those that make a combined use of patent, trademark, and design, so that have a holistic approach to IP, the premium is 98%. So they are twice more performant than small businesses that do not use IP, because they smartly combine all the possible intangible assets and all the possible ways of capturing and exploiting them. So as a last point, I would like to say that, of course, this does not establish a causality. This highlights the specificity of these animals that companies, industries that invest in intangible are. They are more valuable, they create more value. And we could argue also, this is an argument we hear in Europe, that it's a reverse causality. So successful businesses can afford to invest in IP. So in response to that, we have another study also with our colleagues from EU IPO on where we have been looking at small businesses. And basically, we have taken a period of 3 years, checked whether they have been filing using IP in this period, and then we look at the next 3 years. So it's still not a causality, but at least you check the success afterwards.
Right.
And we find actually a strong correlation between the prior use of IP and the likelihood of growth afterwards, or even of a high growth, meaning plus or at least 20% of turnover growth during 3 consecutive years, so quite a high bar. So there's a very strong correlation between prior use of IP and any growth indicator. And interestingly, this correlation is stronger the smarter the use of IP. So when they use European IP rights as compared with national IP rights, they are more likely to grow because they are not only innovative, but also geared towards international growth. And likewise, when they use the IP bundle, so trademarks together with patents and designs, they grow faster, they are more likely to grow. And so that's the kind of results we produce, and that that are accessible on our website, of course, if there is any interest in the audience. We have some other studies on more the use of IP, but I keep that probably for later in the discussion.
So Yann, this is why I would like to share with the audience. We call ourselves mild-mannered economists because we would never make claims that go beyond what we know can be proven by carefully considering issues of causality and making sure we can back them up. So any numbers here will be, presented with great caution. So I would love to invite the audience to ask any Q&A at the end of our panel. We'll have a 15-minute Q&A. There's a Q&A box at the bottom of the screen on Zoom. Just please type your questions, and I already see a couple. We'll take them at the end of the panel discussion. We'll have some time reserved for that. So we want this to be an interactive discussion with our audience. What was interesting in what you said is, this idea of reverse causality, that, hey, because the businesses were successful, they invested in IP. I actually don't find that convincing, because if you're already a large successful business, you have other ways of protecting your ideas. But if you're a small inventor or a startup or an entrepreneur, you're really trying to ensure you're protecting your ideas to get venture capital funding and to protect yourself against the big guys, because you don't have any other way to do it. So for them, the IP as a mechanism for protection of ideas is way more critical and almost an existential issue. And that seems to be what your data is suggesting too. They just tend to rely more on IP. So, with that in mind, I would love to connect the dot to sort of a growing conundrum in the United States, in Washington. We are living in an era where we are focusing on, big tech concerns, reigning in the big tech, in the antitrust world. And on the other hand, we are also shifting the pendulum too far in the direction of weakening intellectual property rights. So on the one hand, we are trying to ensure that big tech is, not the only driver of innovation. And on the other hand, we are trying to weaken intellectual property rights, which, frankly, is worse for small inventors and SMEs and startups, and good for big tech because they have other ways to protect their ideas. So it's a dichotomy that needs to be addressed. It's I call it a paradox, but more on that later. Turning to you, Andrew, your office has done similar studies on role of IP in economic growth. Can you give us some highlights and some plans of the patent office in highlighting and updating these studies?
Sure. So the way that we think about it, and we're a small group within the Patent and Trademark Office. Most of the employees at the U.S. Patent and Trademark Office are patent examiners, and as they should be. And so we have a certain capacity constraint, but we try to do studies in 3 broad areas. So think about, what are the factors that are shaping the inventive process that leads an inventor and his or her company to the door of the Patent and Trademark Office? We also have studies, some studies about, well, after they've reached the Patent and Trademark Office, what's happening there? And then, of course, what we were just speaking about, what Yann was highlighting, is what happens after. What happens after the patent gets granted or the trademark gets registered? And so we dabble in all 3 of those areas. I wouldn't mind later on perhaps spending a little bit of time about what's happening before. because you mentioned weakening of intellectual property rights. When you weaken intellectual property rights, it diminishes the incentives that happen before in the inventive stage, in the creative stage. And it also weakens the assets in terms of their tradability, right? So why would you license my patent if you're really not sure that it's going to hold up in, let's say, a legal context? So weakening on the after grant can actually have feedback effects before grant, which are detrimental to the incentive system that we're trying to uphold here in the first place. That has worked, and we've seen it already. Intellectual property was not a big part of coming up with a vaccine, particularly for COVID-19. But the drug industry, for all of its people that are both in favor and against the industry, they've been super successful in coming up with ways to save people's lives and make morbidity and mortality lower in the world. And many of those discoveries are fueled by the power of intellectual property. So at least the incentive part of it. There's also a ton of scientific knowledge there. But let me jump to the end, that third bucket. What happens? We also have studies that we look at we take industries, we take companies, and we associate with those companies. How many patents do you have? How many trademarks do you own? For instance, those are the two that we care mostly about in the Patent and Trademark Office. And then we asked, how do those holdings of patents and trademarks correlate to the different performance indicators that we have for companies and we have for industries? So Yann was referring to the IP intensive industries. Those are, again, just to repeat, are industries that we classify as intensive because they have, let's say, more granted patents per employee than the average industry. So we essentially take all of the industries and put them into two groups. One group is IP intensive and the other group is not IP intensive. And then we compare those groups and we find, much like what Yann has described, which is surprising in some ways, because remember, intellectual property is jurisdictional, that the US patent is not going to be valid in Europe. And the European, the patent from a country in Europe is not going to be valid in the United States. So there's no necessary reason to think that these are going to be similar results right off the top of one's head because they're different systems. But in fact, the results line up in very broadly and very similarly. I could talk about. We had a report come out in 2016. We're updating it right now. I could tell you what those results are. I mean, IP intensive industries contributed nearly 40% to US GDP. There were 27 directly accounted for nearly 28 million jobs in 2014. We're updating our information on jobs. We're updating our information on GDP. We're updating our information about the premium. There's constant. It's always the case, essentially. We haven't seen it not be the case, where industries that use intellectual property intensively pay their workers more. We call this a wage premium. So we're looking at those three variables, again, in our new report that we're going to be having, let's say, come out in, let's say, 4 weeks or maybe 8 weeks max. We're in the process right now of getting that updated study through the clearance and review. But not only are we going to look at those indicators, but we're also in the new report going to look at things like women. How many women are participating in industries that are IP intensive? What kind of health benefits and retirement benefits are offered to the employees of these companies in IP intensive industries? And I won't go into any details, but it lines up with the other results. In other words, to say there are incremental differences that are between these industries in terms of the participation of women and the other aspects of their job besides their wage, in terms of like health insurance and retirement savings and opportunities. So there are these. We're going to be issuing that report very soon. It's exciting to see this new incarnation of it, and I hope everybody we'll check it out. Let me just throw this out to the group that's listening or perhaps watching, just so there's some information on the table. And This is going to be a website. So it's www.uspto.gov, okay, and then /economics. If you do that, you'll be able to get to the Office of the Chief Economist at the USPTO, and you'll be able to access for free the studies I'm referring to. And we have a number of other studies we could talk about later, but certainly the IP-intensive industries, as we shorthand call them, studies you'll be able to access there. This is the third one in the series of those studies is coming out again in about four plus weeks.
Wow, that's yeah. Go ahead, Yann. You were saying something, and I'll intervene later.
I just have a remark, and these points made me think of that. So he was developing the different dimensions that USPTO is addressing in the next study, and so I was listening carefully, and I hope we can integrate some of in our next one. But there is one that I think is relevant on both sides, and at least that's one lesson we get for Europe, is that very often, so these industries are industries. I mean, they produce things. They are knowledge intensive, but they produce things. For instance, the car industry is IP intensive, definitely. And what we see in Europe, and I'm curious about the US, but I think it may resonate also in the US, is that we have a pattern and a complementarity. So yes, a lot of the R&D job and headquarter jobs are in Western Europe, actually. So there is a lot of value added here, but there are also a lot of jobs created by these industries in Eastern Europe, productive jobs. So there's a complementarity, and there you really see the impact of on the jobs, actually. So it's if you want the factories, basically you have to perform with the technology. And that's I think that's an important lesson for European policymakers, and probably also possibly echoing with the debate in the US.
Thank you, Yann. That indeed it is. And I'm just going to turn to the policy, broader policy context in a minute. I just want to be able to highlight something that Andrew brought up, patents and diversity, or intellectual property and diversity. That's another area of work stream that the CSIS, Renewing American Innovation Project, is looking at. What is the role of the IP regime in really pushing the envelope on diversity? And we're going to feature some programs over a period of time. And I just want to take this moment to highlight, first of all, great work by the US Patent Office in having various programs that highlight the same theme. One of our colleagues, Zorina Khan, who is an economist, has really done this work to explain, long time ago, when there were no other property rights that were granted for women. Patent rights were one of the first ones. And there are records of, creating patents and creating companies by women who otherwise didn't have any access to capital, loans, or entrepreneurial initiatives. So it has been an important mechanism for invention and democratization of invention in many ways, not just for startups and SMEs and individual inventors, but really creating a diversity role for diversity here. So thank you for bringing up that theme, Andrew. I think we all need to, as economists, as those who study innovation, need to continue to push the envelope on that theme.
Yeah, I mean, I can say a lot more about that, because it's a very important effort in our office, but also at the U.S. Patent and Trademark Office more generally. We've under Andre Iancu, we established the National Council for Expanding American Innovation, which is still in existence and thriving. And there's a national strategy being put together about how to expand the innovation system to be more inclusive of women, minorities, and veterans. And so there are many, many efforts, and the office of our contribution as economists actually has been more on the data side, as you're basically saying, Kirti. We crunch a lot of numbers. What we've been able to do, though, is we've been able to apply an algorithm, a set of rules that allow us to predict whether an inventor, based on their name, is actually a male or a female. Mm-hmm. It turns out that works out pretty well. We tested the algorithm. It got it right 94% of the time when we could actually make an attribution like that. When we use that data, and we've used it twice in 2 reports, and this is a continuing research area that we actually are going to be engaging. And we've talked internationally with our other fellow offices, including EPO, about this kind of stuff. But we produced 2 reports, and both of those reports, which are available on the website, are called Progress and Potential, and the second one's an update. But the most recent update with 2019 numbers shows that women only make up 13% of the inventors in 2019. 13% is a terribly small number. It's an obvious red flag that we don't have as inclusive an innovation system as we would want in the United States. And there are a lot of efforts to go ahead and do that. So what we're doing is actually, at the Economist folks, we're just quantifying what the situation is. I think it tells its own story. When you say 13%, you don't really need to tell people that's a low number. They get it. It's especially low if you think about how many women are getting degrees in STEM. I think it was 29% of the degrees in STEM were going to women, but yet 13% of those women are translating those into patents and to be inventors on patents. So there's a lot going on there, but it's a very important area, and I'm excited about the international interest across the ocean in Europe and elsewhere about building our evidence base on this issue and expanding and coming up with new ways to really engage with women and minorities and veterans in such a way that we can expand the system.
Very interesting. And Andrew, I think both you and Yann mentioned that the IP system creates jobs that are, like in an IP intensive industry, the kinds of jobs are more, higher paying, more knowledge intensive and things like that. Last comment on this topic, and I promise I'll move on, but I can't resist this because I think Yann and Andy know this, but for many others, before I turned to the dark side and became an economist, I was an engineer and I have patents, and wanted to do this study to try to understand, what are the indicators for who patents and who doesn't, and really, once we control for a number of predictors like education level and what kind of project you're working on and gender and all that, it really turned out that, exactly what Andrew is saying, that, fewer patents from, based on gender, but really the reason for that was self-selection or some kind of selection into roles that don't require patenting. And we need to fix that. That's a systemic issue. And a patent system plays a really important role in that because it gives you that venue, that opening to be able to fix it. More on that coming in the diversity talks, in the patent and diversity series. Let me quickly jump back to, economic contribution of IP more broadly. So look, there are so many ways of articulating economic contribution of IP to the economy. You guys have done amazing work in this area, with your reports and other studies. Where are we failing? Let's just pause here and ask ourselves this question, because, we are in perhaps in some kind of an echo chamber right now where we recognize the importance of this important mechanism. But of course, we've all heard some concerns and criticisms, perhaps by special interest groups, nevertheless, on concerns with the intellectual property system, that there are too many, quote unquote, weak patents or a thicket of patents or patents that aren't, that are undermining the innovation progress in the innovation economy. So how do we handle that? And how do we make sure that we, treat those concerns not, my view is that many times those concerns are laid out as anecdotes, something happened on the side here and some, mom and pop shop got some, letters for, paying royalties. But they capture our imagination. But as economists, we recognize that we need to look at the problem as a systemic problem. No system is perfect. No system is perfect. Every system will have some cost, some failings, some things to reckon with. So how do we view these concerns that we are hearing, and how do we manage them as we try to come up with these tools for measuring the importance of IP in its economic contribution? Whoever wants to start first. Let's start with you, Andy.
Oh, with me, okay. That's fine. I was talking last time, and I thought I was talking.
All right.
But I'm happy.
Yann is happy.
I don't want to take all the time, but I'll say you've actually highlighted a very important area that's very complicated. Okay, so this is kind of the post-grant. After you get your patent, you stand there with a piece of paper in your hand, and you have an exclusive right, and you say, okay, now what? Well, there are a number of challenges, right? So first of all, it could be that you're able to license that patent out, but it might also be the case that somebody tries to use that idea that you have, that invention that you have a patent on, and so they're called an infringer, right? So they create maybe a new product that's based on your patent. So you need to go out and you need to figure out, is there an infringer out there? So you have to enforce your patent. Remember, in the US, and I won't speak for European law, but the patent is a right to exclude. So in order to exclude somebody from using what you've got a patent on, you have to find them using it and tell them to stop. So there's this challenge to find these folks, and then, of course, to take them to court or to perhaps challenge them at the Patent Trial and Appeal Board at the USPTO. Both the litigation in courts, non-practicing entities or patent assertion entities, and the Patent Trial and Appeal Board, which is at the PTO, all three of those areas are very controversial and unsettled at the moment. When it comes to litigation, there's a lot of discussion about the costs of litigation and the burden on small businesses. Patents do allow for a democratic participation in invention. But after you get that patent in your hand, oftentimes you have to be able to defend it and or get those folks who are infringing out of the marketplace, and that costs money. So the costs of litigation are an issue that are facing a lot of small and medium-sized companies. It's a big public policy question. I don't have any deep insights into it. It's an important discussion. These patent assertion entities, sometimes negatively referred to as trolls. I don't buy into that particular language, but they play an intermediary role, right? And they can actually do positive things for the economy. It doesn't have to be a negative thing. Dean Kamen. I remember a conversation with Dean Kamen. Dean Kamen is the
inventor of the segways.
The inventor of the Segway. I'm just going to say it. Dean Kamen invented the Segway. It's an incredible thing. We all take it through. Every time you go to DC, you want to get on one of these to do a tour, right? Because it's fun. So, and Dean Kamen said to me, and I don't think you'll mind me repeating it, he said, well, I'm a non-practicing entity. I come up with these inventions and I license them to the companies that have the wherewithal to actually produce them, do the proper marketing, get them distributed to customers and so on. I can't do that. So I produce, I invent, and I license. And he said, well, that makes me a non-practicing entity. Am I a bad player? And the answer is no. So there are many good examples of non-practicing entities that engage in the licensing and the intermediary role, right? Sometimes they're third-party companies. And that's a very important thing.
Which is what you were saying, disclosing your ideas and sharing your ideas.
Yes, exactly. And then finally, there's the Patent Trial and Appeal Board, which is a relatively new entity, which was created by the America Invents Act in 2011. And it's supposed to be faster and less expensive option to district court litigation. There's a lot of controversy about different aspects of that, which mostly are there's a lot of legal nuances there that economists are not quite as involved in. But so yes, after you get the patent it's important to be able to monetize that and to be able to create a product or service in some way to get that return for your effort. And licensing has become one of the most important areas of study these days. And I would just highlight that as one of the things that everybody should keep in mind as a very fruitful avenue. Once you have an invention, you can license it, just like Dean Kamen has.
Thank you, Andrew. Over to you, Yann. Before that, let me quickly remind the audience, please put your questions in the Q&A chat box. We are going to get to you shortly. Yann, what do you have to say about this?
So it's a vast topic, and I think the controversies that you mentioned, they are very much related to digital technologies, software standards, and I think we should recognize where they are coming from. You said at the beginning that 80% of the value of companies is based on intangibles, and a lot of these intangibles consist of digital technologies and software. Actually, now you find these digital technologies in farming, in I don't know what, in roads, in cars, everywhere. They create a huge lot of value. So they are very central to the economy, and I think the climax of this value is probably standardization, because nobody is. I think Andy, you said it already that for instance, the usual example in a smartphone, you have thousands of patented inventions belonging to coming from hundreds of different inventors and companies. So it's a lot about licensing, about finding ways, organizations to make that work together, and the standards make it possible. And the standards are themselves very sophisticated technology platforms with a lot of patented inventions in them, and driving a huge lot of value, basically. And I think that means that on a license for these patents, if you change one hundredth of digit, that represents a huge lot of money in one direction or another. Mm-hmm. And when there's a lot of money at stake, you have a lot of disputes, and the disputes may spill over in the policy arena, in the lobbying area, without having any prejudice of who is right or wrong. I think this is just what is happening. And to me, that's more a signal of the value that is created by this ecosystem. At least this is part of the story, and an important one. That being said, there are also concerns that there are other aspects. You mentioned non-practicing entities or whatever controversy that may rise. We need to listen to it, and we need to take it to check, actually. And the way we see it at the EPO is that we need to listen to that, because we need to provide the right system to support continuing innovation. And our answer is always the same. So easy to say, but more difficult to do, is to provide quality, stability, predictability of the patent system. And so constantly invest in quality, in training, in collecting prior art, in improving our search techniques, and also in understanding new technologies. I mentioned software, so we have it took time, but now we have a clear and predictable framework for patenting software as a technical solution to a technical problem. Now the next question is artificial intelligence. So we try to provide the maximum clarity to our users in that respect, and we do that in coordination, in constant discussions with our fellow patent offices, including, of course, USPTO around the world. So I think it's not a very fancy answer, but that's what we have to do. We have to constantly focus on quality, stability, predictability, transparency of the system.
So I really appreciate that insight, though, because I'm sorry, let you finish. Didn't mean to jump in.
I just had two small points. Another one is so that's the EPO is focused on granting patents, right? We are not so patents and granting patents. So then there is like USPTO, then there is the litigation stage and so on. And so talking from the European perspective, we also have to ensure predictability, consistency of the system. and there, our usual issue in Europe is that we have many countries, so it's about harmonization between the countries. And I just wanted to mention that we are advancing with the unitary patent. So in short, a patent for most of the single patent and court, the unified patent court for most of the European single market. And that will be a game changer in that respect in terms of simplicity and predictability. And the last element I wanted to mention is that we have been publishing last December our second edition of our study on the fourth industrial revolution. So tracking patent applications related to smart connected objects. So exactly the technologies I was mentioning. And I don't want to say it wrong, so I should know it by heart, but if I remember correctly, the growth rate on average during the past decade is between 10 and 20% of innovation in that at the world level. So it seems that innovation is going on. It's happening. It's moving in the positive direction. There is no break. It seems so far.
So Yann, the reason I appreciated that insight, I really want us to unpack this for our audience. You know, what you mentioned is critical to underline. If there are disputes, if there are challenges to intellectual property regime or the patent system, let's say, to recognize that they're happening because 80% of the value of firms is in intangible assets. Firms are going to have disputes about things of value. So just disputes isn't an indicator of a problem, which has been a narrative sometimes in various jurisdictions, not just in Washington. But it needs to be taken into account in a systemic way. In fact, I think it's another plug for everybody to consider looking at, reports of mild-mannered economists, like the offices that Andrew and Yann are leading, to try to fully understand what are the pros and cons, the balances, and after all of that, what is the role of intellectual property in driving economic growth? So please, let's remember to take a systemic view. I guess I'll, ask a final question and jump to the question and answers from the panelists. Any word, your, closing remarks on where you think each of your jurisdiction is going in terms of, intellectual property policy and how that affects your work?
I guess I can start since Yann already went before, so that's good. There are a number of issues that need to be addressed. I think the one that's kind of highest on the radar, if you will, is what's called subject matter eligibility. In other words, is the invention that you have discovered or created or derived, is that invention eligible to be patented? Can it receive patent protection? And that question is a big question in the United States right now. And I'm not a legal scholar, but there have been a couple of Supreme Court cases. One of them is called Alice Corp versus CLS Bank International in June of 2014. That particular case in the Supreme Court introduced and extended a prior ruling by the Supreme Court about how to evaluate whether a patent, the subject matter of the patent, is eligible to be patented. And the particular wording and the particular methodology that they talk about in that Supreme Court ruling actually introduced a lot of uncertainty in the US environment. And it was particularly related to abstract ideas. What we know that artificial intelligence technologies are usually embodied in some kind of computer program or algorithm of some kind, and are often stated in some abstract ways. And so there has been kind of an injection of uncertainty into the US environment about whether these kinds of important new technologies are actually eligible to be covered by patents. And that, we have a study actually on that from the Office of the Chief Economist, where we got a lot of help from lawyers because we're not experts in the law. It's called Adjusting to Alice. And it shows a couple of things. Number one, the Alice decision introduced a lot of inconsistency in patent examination because the language of that particular ruling was had so much leeway and arbitrary and vagueness to it. But it also increased the number of rejections that the office gave for patent for ineligible subject matter. Now, subsequently, under Andre Yanku, there was an examination guidance given to patent examiners, and that helped put more structure onto how to interpret what was the Supreme Court ruling. That ended up reducing the uncertainty or the inconsistency in the examination process, and also reduced the number of rejections for initial rejections, called first office action rejections, for patent ineligible subject matter. So the office, what I learned as an economist, right, is that the office is as part of a broader system. And when a Supreme Court issues something, it's like a wave. It travels across the ecosystem and it hits the office, and the office is like it's unstable for a while.
One of the many pillars.
Rebalance, right? And so this is a very important area, and it's an area that I think that there's going to be a lot more discussion on, particularly related to U.S. competitiveness and in patenting inventions in the kind of the hot technology areas that I think concern a lot of the folks who are part of CSIS.
Thank you, Andrew, for those insights. Yann, what do you see coming out of the?
So I have first to say that the EPO is not a European Union institution, so it does not matter much for you, but it means I cannot speak on behalf of the European Commission, for instance. It's two different things. But of course, so we are an independent international organization in charge of granting European patents, and with more member states than the EU. But of course, what the EU is doing is very important. It's kind of defining our context. So that being said, I will talk about what is happening policy-wise in the EU, and I would say, in general, there's a lot of focus on innovation and technology now, and with two main items. The first one is a digital transformation with these new technologies that Andy mentioned, AI and so on, where Europe is not as advanced, in fact, as the US or China. Or if we count the patents, for instance, we see that. And so there are a lot of efforts done to catch up and to perform there, to support innovation there. And the other aspect is sustainability, the Green Deal, and that's really perhaps even more important currently today in the EU. So I mean, we have all seen this summer everywhere the fires and so on. So there's really a sense of that something needs to happen, the clock is ticking, and that the solution is very much at the level of the technology and innovation. And actually, we have little time to scale up a lot of new technologies, and this is a huge challenge. And a lot of the momentum, the policy momentum, is directed there, and that also implies a strong focus on innovation, on deep text. And how does it translate to us? So the first one, it's as Andy said, so understanding these new technologies, making sure we provide the right legal framework for the patenting of these technologies, having a continuous watch and dialogue with our users and with our fellow offices in that respect. So same thing. But also in the current policy context, as I said, there's a lot of focus on innovation, on startups, on funding, and that's a bit new from a European perspective. Things are happening actually, and ecosystems are emerging. And for instance, funds from the US are arriving now and starting to invest in Europe, bringing their experience and culture. That's very good news for the European ecosystems. And there's a lot to do with respect to the IP culture in startups, in VC funds. There's a lot to do in terms of universities, also leveraging the good research we have into commercialization, as Andy said, and again, IP is instrumental there. So the office has a role to play in that respect, clearly. So we focus a lot on that. And I mentioned already, but that's fundamental, the unitary patent. So we have a very big market, one of the biggest markets in the world. But we have to fully realize it when it comes to innovation, because the patent system is still fragmented. You have national, well, once you have a European patent, you have to validate it in the different member states. It transforms into a German, a French, a Belgian patent, and so on. And with this unitary patent coming now, likely next year, that will really be a game changer, because we will have a patent system at the scale of the European market, especially to scale up new technology.
Much appreciated. So let me open this for Q&A from the audience. Thank you again for participating in this panel. You know, as we continue the Renewing American Innovation Project and the summit this week, we're going to discuss more and touch more upon these themes of what are the continuing challenges on intellectual property today, like the ones that Andrew and Yann mentioned, like what's patentable, what's not, and how do we streamline the patent system, or how do we make sure that patent owners get the protection they need to be able to challenge the use of their patents in courts. If that's not happening, then not having a patent is valueless anyway. So all of those things will be discussed in light of, an understood policy goal we are all behind today in driving and renewing American innovation. So we'll continue that discussion. In the meantime, let me open this to Q&A from the audience. Again, please type your questions in the chat box. Let me start with the first question. So it's from Tony Carroll, who's an adjunct professor at Johns Hopkins. Thomas Piketty spends little focus in his book Capital on facilitating the role that capital plays in innovation. Does he adequately account for societal benefits of innovation that you describe? And have you discussed this with Dr. Piketty?
No, I'm actually not familiar with Dr. Piketty's book, unfortunately.
Capital in the 21st Century. I thought we all read it 3 years ago or 4 years ago when it became suddenly the talk of the town, and then it wasn't anymore.
Yes, I have to admit that I have a stack of like 3 stacks of reading that I'm behind, of books and magazine articles that I'm behind it. So maybe I'm not a good example. I apologize for that. But there is this change, right? We're not in a physical capital. We're not, as you pointed out already, Kirti. I mean, we are in a world of intangible capital, where value is really embedded in intangible capital. And not in capital itself. So if capital is plants and equipment, then that's part of the equation. It's the traditional element, one of the traditional elements economists have looked at, and it's still there. It's still important, but it's not the most important form of capital anymore, I guess. I don't know more about the book, otherwise I could say.
Let me jump in here, if that's okay. But I have a certain view on this. It's actually, I think that the fundamental takeaway of his book, that return to capital is growing faster than incomes. So if you have more capital, you're just going to be richer, no matter what, because that's just how it is. In the 21st century, that's true. Why? Why is that true? It's because it's the first time we are living in a world where we are all taking a bet on and investing in economic growth. That's why the return to capital is higher than return to anything else, especially income. So it's already taking into account the idea of the importance of innovation, because that's what's driving economic growth. Never in the history of humankind was this ever true before. We never invested in future thinking we'll get more money in return in the future. We were in a zero-sum game. So this is the modern economy, and it's true because of innovation. So I think that's sort of already a feature of his thesis, and it supports our view. Yann, any words from you?
Well, I think the main focus of the book is not innovation, so it comes by it's not at the heart of the system. I think the way you described it, Kirti, is right way. What I would just say is that if we translate that into the world of, if we try to ask these kind of questions in the world of IP and innovation, to me, we have to reformulate it in terms of intellectual capital. So we said that that at the beginning, for instance, we have said that employees in IPR-intensive industries have higher wages because they are more producive, because they are better skilled, they have higher intellectual capital, because they have been educated and so on. And I think this is a great factor of inequality. Actually, putting it differently, education matters to access to investment and so on. I had one. Yes, and I just wanted to close the loop also with this decentralized nature of the patent system and this remark you made, Kirti, on women in the US and the patent system. So actually, it's very important to empower people to have access to innovation, to innovate, to bring the innovation to the market, to create value that way. And education is important, and IP likewise in that context.
I guess there's
next question for both. Go ahead, Andrew.
Let me just. I just read the question in the chat, and I guess one of the things that that Tony Carroll is asking about is this difference between a private return and a social return. At least that's part of what I'm reading here. And we can invest some money in some kind of capital, whether it's a new plant or equipment or financial capital or something like that, and we can earn a return, right? We know there's a risk and return trade-off. However, that's a private return. That's what I get from my investment in that particular asset. What we often get in innovation is a broader return, a larger percentage return, because other people benefit beyond me from my innovative activities. And this is the point that Yann made earlier today. I think that very dramatic differences in the social and private rates of return. So I guess the answer to the question the way I'm reading it is no, he does not adequately account for the societal benefits of innovation if he is not incorporating the benefits to others from innovation, not just to the innovator, him or herself.
Interesting take on this. Let me ask the next question. I think it applies to both of you. Can you share some concrete examples of savvy use of complex IP strategies that bundle patent, trademark, and copyright protection versus those that rely on a more simple or a single type of IP protection? And what contributes to a company's use of these more complex and IP-intensive strategies? It's a question from Laura Savatsky, who's a tech transfer officer at Varsity and AUTM chair.
Yes, so happy to jump in. Actually, I love this question because that's a question I'm asking myself a lot. And actually, when you start looking at these strategies, it's just fascinating and endless. You have so many examples and so many creative ways of playing with IP and building a business model around that. So I will just mention that for that reason, we are regularly conducting case studies and publishing case studies of small businesses that use the IP. Well, that IP bundle in different ways. Can be startups, can be family businesses, any sector. And one example is I have in mind is Marinomed. It's a biotech company from Austria. They use compound derived from red algae to fight the flu, and they have a dual licensing model. So they combine patented technology with a strong brand, and actually they license part of they distribute part of the technology under their brand, but they also sub-license the technology to other producers under their respective for distributing under their respective brand. So that's one way actually to play with the control of the brand and the patent, and you can use that for different purposes. Like for instance, economies of scale. If you produce everything, you can reach economies of scale, but differentiate in quality using the brand. Or there are various other ways, creative ways of playing with this combination. So that's one example among many. And if you are interested in other examples, There's this, so these case studies are available at www.epo.org/SME.
Yeah, those are good case studies. I remember you mentioned them before to me, Yann. That's wonderful. I mean, I think that just my 2 cents on this. I don't pretend to be an expert on the business side of IP strategies, but from what I can see, these forms of IP, copyrights, trademarks, and patents are used and trade secrets are used together all the time in complementary ways by savvy companies. I mean, just think of the Apple phone, right? I mean, the whole brand, the branding of the Apple phone is incredible. Trademarking going on there. There's plenty of copyright on its written materials. There's patents in the phones. Coca-Cola has design patents on its bottle shape, which it keeps. It's got incredible trademarking. It's got a trade secret, the Coca-Cola formula. I mean, these companies are using this. This is all over the place, I would say. It's all over the place. Yeah. And so it's very common, and it's a very smart way. I think as economists, and Yann actually has a paper published on this in a journal, and this is about strategies of patenting, international patenting strategies. And I think that in and of itself, even without the other forms of IP, is a really important thing for us to get our arms around as this global economy is continuing to evolve. What's happening around the world? So international patenting strategies are a very important topic.
Yeah, well, on that note, we are out of time. But thank you, everybody, for the questions. Thank you, Andrew and Yann, for taking the time and take part of the our Innovation Summit. For everybody who joined today, a big thanks. And again, you can find us at csis.org, US Innovation and Competitiveness Summit. It's going on all week. We have a great set of panels on similar topics. We hope to continue to see you there. Thank you again.
Thank you, Kirti. Thank you very much. Thanks, Yann. Bye, everybody.